Wake up, praise Allah, it's a beautiful day. Family, friends, and fun. What more can I say? More is coaching everywhere. It's all on display.
It can be submitted as evidence because he's not a competent fact witness. He cannot swear to the affidavit on the record. So there is nothing on the record other than the affidavit you put on the record.
And a third party can't do an affidavit anyway, right? No. See?
Competent fact witness. And when if there was an injured party and they hired an attorney, guess
He
what?
can't be an injured party.
The
They
lawyer
lose
can't
anyway
speak,
because they became a
and
part of
he
the
can't
state.
speak because he's incompetent. Exactly.
Right.
So I mean, it's shut down. It's just ain't getting.
Either way it goes.
So if he has an attorney, can he still submit an affidavit?
Nope.
Is he still incompetent?
No, you can't. Only the lawyer, the only one can submit anything. You realize when you're in court, the judge will not let you speak. He would tell you put a muzzle on it. The lawyer's speaking here.
Right, but I'm saying if he submitted an affidavit, he would be putting something into the record as opposed to speaking.
You can't.
He can't.
You can't.
He's not going.
You're no longer. See, you part of the court. You're part of the fiction. You have no standing. Especially when there's another flesh and blood there acting on his own.
What's that term? You are civilly dead? Yeah.
Obligation, the binding power of a vow, promise, or other oath or contract, or of law, civil, political, or moral, independent, or of a promise. That which constitutes, and by the way, a judgment is a promise. Is a promise. And becomes a promissory note. That's what I said. When you put that on the financing statement, it becomes accounts receivable. All you have to do is know how to make it into money, or how to use it and such. Well, I suggest we get a bunch of them and go open up an offshore bank. Yep. Legal or moral duty in which renders persons liable to coercion and punishment for neglecting it. An obligation or debt may exist by reason of a judgment as well as an express contract in either case, there being a legal duty on the part of the one bound to comply with it and promise. That's why I say a lot of times when you understand the codes dealing with contract law, when you write on these tickets, like I told y'all before, my nephew had about 9 tickets. And all we did was put refuse for cause, unconscionable, yada, yada, yada. And the tickets never went into default. But he got 3 more after that, and he was on his own. He said, I'm not playing this game with you. But they're never going to default because as long as you don't go here, you stop the contract. Offer and acceptance. I accept it and I refuse it, and I give it back to you. It's a fraudulent contract. When I put the fact that I say that it's unconscionable, refuse the cause without dishonor and without recourse, it's an unconscionable contract. What is the benefit? What is the agreement? What was the consideration? There is none. And I'm refusing to accept your offer to contract. I do not wish to contract. All of that is evidence. If they ever try to bring you into court, you got copies of those documents showing what you said and how you responded to those documents. They cannot stand. Because they cannot go into default, and a warrant cannot be issued because there's no binding contract.
Just like Califa was saying, I went through the same instance. That the same thing happened to me, and then they sent another notice, and I stamped it, refused for cause. Then I stamped the letter that they sent as mail fraud. Put them in an envelope, sent them certified with a return receipt. And I've seen neither hide nor hair of them.
They lost it.
Right.
That's a crime.
Question, but there are no liens against you and no warrants for those citations, are there?
Yeah, they still pursuing.
Oh, they are?
Yeah.
Then you need to take your copies and put them on the financing statement and foreclose.
Doesn't he have to check UCC 11 first to see if there's anything there? If they filed anything?
They ain't filing no tickets on no UCC.
I know, but you still have to make sure
No, he don't
first,
have,
don't you?
No.
You don't have to, oh, that's right, that's for liens, you're right. Hush.
Well, they talking about leaning my check and all of that stuff.
But they haven't done it yet,
For what?
they're talking about.
Right, yeah.
For what?
For the tickets.
Then you need to hurry up and correspond.
I did. That's what I'm, well, and I'm also doing it in the process.
Same
Yeah.
thing.
Right.
Okay, well, I'm gonna say it again. You need to foreclose.
How do I go about foreclosure?
Finish up the process. You refuse the tickets how many times?
Twice.
Twice.
Right.
Give them a notice that you have disputed, yada, yada, yada. Give them that notice, give them
Send
time to
copy of
respond.
the, certified and everything.
Okay, then you pretty much exalt, what I'm saying is format that process into the administrative process. The first, second, and create a third one. Now you gotta make that third piece of default. Because they failed to respond, you refuted the contracts. And they failed to release the contracts, et cetera, et cetera. Make that third part the closing aspect. Make it the default judgment. And file it on the financing statement, because you now own. And I'm gonna try to get to that real quick. As a matter of fact, let me hush up and I'll go back to this so I can show us into a foreclosure process. If we hold the questions, I can get through most of this. It's a lot. Huh?
You right
write it
there,
down.
you said give him time.
Write it
How
down.
much time for the notice, how much time for the fault, and how much time for the default?
How much time you choose? 3 days, 7 days.
Well, I was reading in one of your flyers, it says that according to what Hebrew law is supposed to be doing in thirds.
Just complete it in
Are
30
you a
days,
Hebrew?
all three in 30 days. All you need is 30 days altogether.
Total.
That's it.
And cause
Okay,
just complete it in 30.
okay.
Okay, you come in, go back 1 second right quick. Let me see what I missed. And thank you, by the way, but okay, contract. Promissory agreement between two or more persons that creates, modifies, and destroys a legal relation. Come on up. Becoming a secured party by creating a security interest. This is the part that they really don't like. Come on up. We're going to go on pass off. I'm going to just deal with some of the definitions. Uniform Commercial Code. Do we know what that deals with? The Uniform Commercial Code is the law of contracts on the quasi-admiralty maritime level. The Uniform Commercial Code is the governing laws for all the courts over here and all the banks, because they're one and the same. They're not acting, they're quasi-admiralty. They're not dealing with international law. They're simply dealing with the Uniform Commercial Code for contracting purposes, which allows them to create fictitious contracts and railroad you into their system to take advantage of you. The Uniform Commercial Code is the law of contract on the state level. Scroll on up. Or within the corporation. Come on.
Mow up.
Yep,
Mow up.
Mow up. We ain't gonna go through the whole, all that code. Financing statement. A document filed with the lender. A document filed with the lender. So if you're filing that document, you are in the position of the what? The lender, who's the secured party, who's the holder in due course. And under the Uniform Commercial Code, you cannot bring a collateral attack against the holder in due course. Detailing personal property taken as collateral from a borrower. The financing statement, a standard document under the Uniform Commercial Code, is filed with the Secretary of State or other designated public official. The document is time-stamped, the filing date is noted, and the file number is assigned, securing the lender's claim to the assigned collateral. It's secured, and no one can unsecure it. And right now, they're in the process of trying to modify the laws and things to confuse you about your right to file a financing statement. Go ahead. Security agreement. A document giving a lender security interest in asset or property pledged as collateral. This agreement, when signed by the borrower, describes the collateral and its location in sufficient detail so the lender can identify it and assigns to the lender the rights to sell or dispose of the assigned collateral. If the borrower is unable to pay the obligation, the security agreement may contain loan covenants governing the advancements of funds and schedule for repayment, principals, interest requires the borrower to obtain insurance coverage for the assets pledged, yada, yada, yada. Security agreement may cover a non-possessory lien in intangible property such as accounts receivable or possessory liens in which the lender holds the collateral, for example, stock certificates, until the loan is fully paid. In some loans, the security agreement is also the financing statement. Security agreement, which is what all banks and mortgage companies want to get their hands on. Security agreement they call a mortgage, but it does not mean real estate. That was the case I was trying to pick up off the internet. The partner was trying to send to me. Mortgage is a security agreement. Security agreement is a financing statement. Security interest. Lender claims to assets pledged by a borrower securing payment of an obligation. A lender's interest, also known as a lien, it is said to attach to the borrower's property and consist of two limited rights: foreclosure and priority. A lender who files a financing statement is often the same document as a security agreement with the appropriate state or county officials, gives legal notice to the other creditors that a lien has been filed. This process, known as perfecting a lien, commonly done in the commercial lending of a lien that is valid against claims of other creditors and most third parties. See also perfected lien. I said earlier in the federal codes of the Attorney General, they have said that the state lien, the financing statement, is the superior lien, and it supersedes federal. That's why I told some of you guys who deal with the Internal Revenue, when you go and get a certified copy of a search, when they claim that they have a lien against you, and there's no lien in the UCC, you got a certified document as Exhibit A that a fraudulent claim has been filed in the county. You can take that 11 over to the county along with an affidavit to remove the fraudulent lien via Exhibit A. There is no lien on file in the state, so there is no lien. Everybody hollering about the UCC and filing their straw man and all that nonsense and not understanding what the hell its purpose is and how to actually file a lien. If you ain't got an administrative process against the straw man, you don't know no straw man. You don't. You just can file a fictitious document, and that's why they get ready to change some rules up so that they can stop people from doing what they're doing. Because half of them don't know what they're doing anyway.
That's why they keep saying like frivolous file.
Hey, where is the support to that lien? See, you no different than the Internal Revenue. You filed a lien document when they ain't got no administrative process, no court judgment to support it. And I told y'all we had a cat in Detroit listen to somebody and they told him to go file liens on the police without an administrative process. He got 3 charges, 3 federal charges.
Federal outside of DC though, right?
Perfected lien, security interest in collateral securing a debt protected from claims by third parties. Properly filed lien takes a security interest in property owned by the borrower. A lender must file the lien with the appropriate legal authorities for perfection of the lien on real estate is accomplished by reporting the mortgage deed of trust in public land records of a municipality such as the town clerk office. One of the processes when you file your lien in the administrative process in the registry, which is cheaper, you can now take the financing statement and file it in the county recorder's office, telling them to go to the UCC division to pull up the entire piece. But it's valid.
You file the financial statement only rather than the whole.
Exactly, because you know that's, you be talking about $2
million.
Exactly.
Yeah, that's what.
Plus.
That's why they do that. But see, that's the whole key. Once you file the entire process into the UCC, all you need is the financing statement to go and take over to and put a little affidavit saying, see the UCC filing for the rest of the documentation. Real simple. But we got it complicated. Can't be that simple. Scroll on up.
Moving on up to the east side,
Scroll up.
to
Don't worry about
the
that.
deluxe apartment in the sky.
Collateral security interest enforcement. After perfection, the undersigned, no name letter, reserves the right to proceed at expense of the lien debtor with a writ affecting the seizure and sale of property necessary to satisfy the amount due pursuant to subject to commerce lien affidavits of damages and notice of levy.
It's execution time.
Right now, that brother who has that lien on the judge can go after his bank account, can go after his house, and any other assets he has. And ain't nothing the judge can do about it, especially when the marshals come and get him out of there. Rights of the secured party. Self-help, taking action in person by a representative with legal consequences, whether the action is legal or not. For example, a self-help eviction may be a landlord removing a tenant from property, apartments, locking doors, yada yada. Self-help, i.e. without judicial process. Goods, creditors permitted without breach of peace. Where's the repo piece up there now?
There
Go
it
ahead.
is, 3 lines up.
What you're talking about right down there, right?
3 lines
Repo.
up.
Yeah, I missed it. That's what a repo is, a self-help remedy. They ain't going to court. They just going, sending a tow truck to come pick up your car. And because you failed to protest, they get to drive off with it. Your acquiescence is your agreement.
Unless you cause a breach of peace.
Without breach of peace.
When you protest, that's a breach.
Yeah.
The actions is now stopped. And if the police don't stop them, when you call them to stop them, they have just committed conspiracy and grand theft auto. That's the law. Y'all got a Supreme Court case, Suttle versus Cook County Sheriff, which the man told the sheriff to stop him from pulling his mobile home up, and the sheriff didn't stop him, and the sheriff got hit up with conspiracy. Supreme Court case in Illinois. Y'all don't know, y'all got some nice cases that would crack these tow trucks' heads out here. With all this stealing, this vandalism and stealing of private property that they do here. Oh my
Do
goodness.
they have to do with the Homestead Act too?
Huh?
Do they have to do with the Homestead Act too?
I think the Homestead Act is in there. Scroll on up there. Self-executing judgment. Those requiring no affirmative action of the who? What the hell do you need a court for?
What court anyway?
All you have to do is know who you need to exercise your property to go execute your writs. Because if you notice during evictions, you ever see a sheriff come out lately? When an eviction is taking place?
Probably
There are no sheriffs. What do they call them? Bailies?
Bailiffs.
Sheriffs don't come out. Because it's not a constitutional action. They have hired these cats to go and exercise these private...
Bounty hunters almost.
Yeah, that's what they are. Bailies are private contractors that you don't have a contract with. It's, yeah, similar. It's just like the sheriff when he's having the sheriff sell. Where's the contract authorizing the sheriff to sell private property? Because in the sheriff codes in Michigan, it says that he can only auction off property that is that owes taxes to the state. And it has to be public property, that it can't be private property. I mean, the whole thing is such a fiction over here. It's just, I guess it gets mind-boggling sometimes. Go ahead on. Execution, carrying out some act or course of conduct to its completion. Northwest Steel. Domestic finance. The completion, fulfillment, or perfecting of anything or carrying into operation of effect and effect. Scroll on up. Rights after default. Rights of secured party after default. After default, a secured party has the right to provide in this part and except as otherwise provided in section 9-602, those provided by agreement of the parties. A secured party may reduce a claim to judgment, foreclose. If you got that citation and you done did your piece against it, and you followed it on the financing statement, they're foreclosed. you own the case. That's a whole other aspect of this administrative process. When they bring an action against you and you counter their indictment and you challenge them and you send them a notice of fault and default, you file that judgment on that financing statement, it is not their property nor authority anymore. It is your contract, not theirs. And the hold in due course cannot be collaterally attacked. These people are all under contract law in the Uniform Commercial Code. May reduce the claim to judgment, foreclose, or otherwise enforce the claim, security interest, or agricultural lien by any available judicial procedure and, scroll up, and non-judicial. Collection and enforcement by the secured party, non-judicial enforcement of a mortgage. Now y'all think that means a house. It does not. It's a security interest. Y'all heard me read it earlier. They called it a mortgage, but it's the securing of security interest by filing a deed in the county recorder's office. That creates a mortgage. Filing that default judgment on the financing statement is a mortgage. It's a mortgage. It's necessary to enable the secured party to exercise under subsection A3 the right of a debtor to enforce a mortgage non-judicially. The secured party may record in the office in which the record of the mortgage is recorded, scroll up, a copy of the security agreement that creates or provides for the security interest in the obligation secured by the mortgage, and the secured party's sworn affidavit in reportable form stating that a default has occurred. It's all there. It's all there.
The secured party is entitled to enforce
The mortgage
non-judicially.
Now let me ask you a question. Ain't no mortgage company nowhere filed no damn affidavit.
They can't.
But those we call them, no they can't. It's, I'm gonna tell you, holes, the bucket ain't got a bottom, much less holes. Your contract is the security agreement. The affidavit entitled Notice of Default is the sworn affidavit in recordable form stating that a default has occurred. And now you can compel performance.
secured party's right to take possession.
Party may proceed under Section A without judicial process if the proceeds without breach of the peace. Scroll on up. Public Law 89-719, which states that the federal and states are under the Uniform Commercial Code. Public Law 7310, Uniform Commercial Code.
Come on.
Public Act 174, Michigan Uniform Commercial Code. Every state in the Union is under the Uniform Commercial Code because they're all corporations. And this is the bylaws of the corporations, the rules and regulations in the corporation. And if it works for them, it works for you. Go to the hold in due course document.
Is it down there?
It's in the original file. Hold in due course, right there. Did you get the lines out of there for me? Where I get distracted so easily.
What line?
Your borders.
Oh, they don't exist.
Always putting
Let me see if they exist. They don't exist. They're not there. That's only.
That's my navigator, y'all.
Right.
When I put stuff together, he comes in and forms
Cleans it up.
instructions,
Cleans it up.
paragraphs, and oh my goodness. He does a damn good job. All right. Affidavit of notice and demand to cease and desist all court actions and to remove warrant from lien. Notice of removal of warrant and to cease and desist all court actions is hereby served upon you dismissal of all charges without prejudice, and remove all fraudulent warrants fraudulently filed against the real man by Judge Jackass. Per Illinois federal court rules, any allegations not denied is taken as admitted. Statements and affidavits that are not rebutted by the opposing parties, affidavits or pleadings may be accepted as true by the trial court. An unrebutted affidavit stands as truth in commerce. You got the Bible, the codes, and the case laws all supporting it. Default, final default judgment by its establishes allegations of complaint and concludes by law estoppel. Estopped by judgment, collateral estoppel, and affirmative defense barring a party from retaliating an issue determined against that party in an earlier action differs significantly from the first one. As an action of law, the action of the courts and all agents are hereby barred and foreclosed. You are barred by judgment by default. Scroll on up.
That too big?
Yeah, go back to 150. I thought you threw something at me. That's why I was ducking. You are barred by consent judgment. You are barred by acquiescence. You are barred by tacit appropriation. You are barred by obligation. You are barred by agreement. You are barred by contract. You are barred by latches. You are barred by estoppel. You are barred by move. You are barred by stare decisis.
You are barred.
And if you don't stop, your ass will be behind bars. I hope y'all don't mind my dog. Financing statement document filed with the lender detailing personal property taken as collateral from the borrower. Financing statement, a standard document of the Uniform Commercial Code, is filed with the Secretary of State and other designated public officials. The document is time-stamped, the filing dates, yada yada. Real man is the secured party of interest to the financing statement, security agreement. The same definitions we went through earlier, going through the process. Security interest. And all you're saying is you own the process, because you do under the law of contract. It's one of the simplest ways to stop paying madness, and then step over to admiralty to have the contract enforced.
Perfected lien.
Priority of liens. In the case of loans made by HUD, the court in Chicago, Title Insurance Company versus Shear Village, held that mechanic liens recorded under state law have priority over prior recorded federal mortgages. UCC Financing Division supersedes the federal all day long, because they have no place to file liens other than in the county. And the Uniform Commercial Law is the governing law of contracts and liens. So if it's not filed in the Financing Division of the Secretary of State, it is not a lien. There is no lien on the public record. That is the supreme public record. And that's what that venue is for filing judgments and liens. Remedy, the means by which a right is enforced or a violation of a right is prevented, redressed, or compensated. Right of action, the present right to commence and maintain an action at law to enforce payment or collection of debt or demand. Self-help, taking actions, executing judgment, execution. Scroll on up. Come on up. Execution of a judgment. Execution is putting into effect the final judgment of a court. We are a court, process to carry into effect decree of judgment and execution. Rights after default. Again.
Where?
Go on up.
Oh. I got you.
Go on up. We didn't already went through. I'm going to just tap a little into when we get to the state part of it. All the same things. Now we have Illinois State saying the exact same thing. Effectiveness of security agreement, attachment to security interest, rights of parties to security agreements. You control the document. It belongs to you. You control the court case and all that is within it.
Keep on pushing. Pushing. Pushing.
Same stuff that's on the federal is on the state.
Equal protection.
Real man who would be denied equal protection of the law and suffer irreparable harm and damages is 18 judicial pursued, enforced any action of unlawful employment to usurp any unlawful power or jurisdiction over affidavit and can be asserted subject matter jurisdiction, no person of jurisdiction without a valid statute to give the named agent authority to bring a case, to hear a case, and no such statute is present or evidence in this case. Be stopped by judgment. Scroll on down. 5 U.S.C. creates a what? Quasi-independent status for administrative law judges to better ensure impartial hearings. Right. That's a joke right there. But there's the term quasi. Courts do not have jurisdiction to interfere with action of the administrative agency until the administrative remedies have been exhausted. Violation of the administrative law voids agency action. The Universal Supreme Court held that the magistrate has not such jurisdiction, then he and those who advise and act with him execute his process are trespassers. Going up. Equal protection of the law. United States Constitution. No person shall be denied equal protection of the law. We ask them to simply do the right thing. There should be no arbitrary deprivation of life, liberty, or properties, spoliation of properties, arbitrary and capricious scrolling up. In other words, we let them know that you take an authority that you do not have, you will end up paying for it. Usurpation, the law of encroachment, assumption of or the use of property, power, or authority which belongs to another. And the process that they want to enforce now belongs to me, they have no authority. So if they choose to go on and try their nonsense, and basically let them know that a writ of quo warranto and a writ of quo position will be issued for the failure to do the right thing. More cases dealing with quo warranto. Your failure to comply with affidavit demands will cause affidavit to seek writ of quo warranto and a writ of prohibition. There you go. See, all of that stuff is in y'all hands, and I was looking forward to seeing somebody formulate and put those pieces into action. Especially with the writ of quo warranto, because all of these clowns do what they have no authority to do. When you challenge jurisdiction and they move forward, the perfect question is, by what authority are you acting? And they do not like that. Because they have no authority, other than to say, well, you my slave, now own you. And based on what has that happened? Because I did not agree to be an indentured servant. I didn't agree to that. I know I didn't, because I actually issued it.
I mean, that's what see. Oh, you're saying after you have done that, then based on what?
Well,
But that's what they're assuming before then.
okay, well, the assumption has been eradicated. I just gave you the necessary documents.
Right.
Ain't no more presumption at this point because you're aware of the facts.
Right.
You're aware of the facts. All right, what time is it?
6:20.
6:20. Okay, so that means we got about 40 minutes. I apologize for being long-winded. If y'all want me to move forward, we'll cover the expatriation in the next class, which will likely be next class. Okay. Yeah. Is that okay with everyone? Yeah, next class. Whoever's not, we'll just stay here and continue.
With this expatriation, I think is paramount with us doing our paperwork because,
Yes, but this is paramount. And the reason I'm saying that is because, but even the folks who got expatriation documents, they still don't know how to handle their business. Guys getting pulled over and knocked in the head left and right at this point.
but is there a proper way to formulate your expatriation? Because I know it's a few people that have theirs, and one might differ from the other. So that's what I'm saying. Is there a proper way? And there's certain things that must be in that expatriation to make it.
Yes, sir.
Yes. Okay.
Yes, sir.
So that's,
And we have covered everything.
Omari,
Yes,
when would you
ma'am.
have that class?
It would probably be the end of March. I think I'm going to schedule for the end of March. last, Sunday of March, I think it's scheduled. I got
What did I just do?
first, yeah, it will be the last Sunday of March. And we'll send that out ASAP because I got, the next 3 weekends I think I'm gonna be in Detroit.
All right now.
Any questions?
You don't keep your word.
Huh?
You don't keep your word.
Because you want to do Q&A.
Question. I said any questions?
Yeah, you said the question.
You didn't do expatriation in the March.
Next class.
I mean, you don't have to wait to March to expatriate.
Yeah,
Give me a call. We'll expatriate you tomorrow, hell.
yeah, that's it.
So we're gonna ask
You gonna-
I want to expatriate 4 March.
This week?
Thank you.
Wow, I want to say yes, but that's been in the hands of other people, and I'm the one getting fussed at. I will move to make it happen if I have to, yes. It will be ready for next class. I'll get it over to the system.
Yeah, you know.
So the next class on this expatriation is March 29th according to my calendar. That's the last Sunday.
That's the
March
last Sunday? What's the Sunday before the 29th?
22nd.
Huh? If not the 29th and 22nd, I just have to see, because I know I got 2 programs for the month of March, and I know one is at the beginning, and I don't know if the one's the second week or the third week. Yes. Questions? Which one? Oh, yeah, that's the one that we reformatted. Ahab, just shoot it up on the board.
The expatriation?
Yeah, the
Give me a copy.
one in the 5.
Just give me a copy. And I just do mine like that. Yeah, too.
It was,
Yeah, just give everybody
Was it
a copy.
Admiralty
Everybody a copy.
No, it's not in Admiralty. It's in the law class piece we're dealing with.
yeah. Expatriation.
okay.
I think it's in this.
Close that out. It's on your computer.
Right. I just, huh? It's in the law class, right?
It's on the desktop.
There it is, expatriation plan. I had closed it down.
That's not it.
He saved it to the desktop.
We say it's under another name. That's,
It's not in there under anything?
we changed it. That's why I'm saying. It was on the desktop if you didn't take it off. Class doc expat.
Oh, okay, that part.
Now expat doc. And see, what I've also put together is an argument on how to defend your expatriation. Because judges is messing with folks who've expatriated. And this is, I mean, you have to be able to stand.
Expatriation Act of 1868.
That's just the act, which was what he read earlier. What we're gonna also suggest that y'all can start now is simply writing to the National Archives for a certified copy of the expatriation. Because we want you to attach that to your expatriation doc as an exhibit.
Let me get $2 up for run a copy of everybody.
The same place
No,
you
it's
ordered
just
the
ending
treaty
now.
from?
Yes, the same place.
Just run a copy, somebody get a original, we just run a copy. Give you $2 for you.
Yeah, let's do
Because
it.
those are exhibits that you wanna have.
Yeah, and everybody just give whoever get the first copy, give them a couple of dollars to run us a copy. And everybody will have to call.
Expatriation of 1868.
Certified.
Which one you got doing that?
Would that work, getting a copy of a certified copy, like James is just saying? Okay.
Was that number that I gave you last week?
They're all copies
Yeah.
this week.
I
They're all copies
haven't
anyway.
called you yet, because I haven't had a chance to, but yeah, that should give
Oh,
me
click on the,
expatriation activity.
where is it? Cancellation. Go to 150.
Do you have a square exception?
What we're gonna basically deal with is 2 documents, the expatriation and the Declaration of Nationality, which is simply declaring, we don't have to have all the expatriation and the Declaration of Nationality.
So is that considered repatriation and repatriation?
Yes, you give them notice of their proper status. And the tell you, this brother doing some shit that is off the chain. Some good, some bad, but he's doing it, and I ain't mad at him. Ernest Walker. Yeah, the Solicitor General. That's what he calls himself, the Solicitor General, which is the attorney under the Attorney General.
I didn't see what's in
And look,
You didn't have it.
all we need is really that
Expatriation thing is not in there.
the
Expatriation thing is not attached to it. When I said you've been expatriated, it's not attached to it. Unless you added it. Oh,
that's why I said order it and
Yeah,
attach it as an exhibit.
yeah, that's what I just said. What's that say, man?
I just said that you just said that I just said.
I cut and pasted it in there, and just to speak on it. But your brother had the whole document because, and that's the whole thing. If you notice the expatriation document, it says for the protection of who? No, what term are they using?
Family
What
nation.
citizen?
Oh.
American, not U.S. See, you gotta pay attention to everything because it's all in the words.
Yeah.
That document is for the protection of American citizens, not U.S. citizens. That's the whole purpose of it. American citizens. There it is. Right here. That's the internet copy.
Okay. You want
Certified.
yeah.
It's a
Certified.
legal
Give me a
copy.
copy of that June bud.
That's old folks, you can get DVDs as your discount. Okay.
You get two DVDs. You get two of them?
$100 off on
No, on the book.
On the book.
You say you gonna call down tonight?
Okay.
See, I was good, but see, I went out already, but I got a big one. That's why I go back. What's wrong with my stuff?
He was when you were going.
Yeah.
He asked me to call because I was on my way out of the city. Yes.
Muhammad's like in October, man. I'm going for November.
I know I didn't follow up for, because I was sick.
Civil law by,
What are they gonna do today? Like I got money to be thrown away.
what happened with it? You going to tell us what that?
I talked to him sometime earlier last year, and he was supposed to put up some money for me to monetize his lien. And he wouldn't. I was like, I didn't know if he was.
Thank you.
Okay.
George, when was the first time you
Around 10,
in the
with
morning?
10,
I'm not
10
just
and
talking,
11.
I'm talking about generally.
Between 10 o'clock in the morning,
Okay.
between 10 and 2.
Between 10 and 2 for general questions, okay.
And I never got the document back, so the document is good. He said, three times we paid him. You still gonna pay the first week? See, that's why I couldn't do no person came in tonight, because I knew the document. That's on the time to apply.
It says, caution, the loud ringtone of this phone, but it said not of this phone, could damage your hearing. Is it that loud? Ring.
Right.
A little louder than the other one, Mr. Ring.
Some lawyer for some.
Your documents for some reason more than anybody else's.
Thank you, sir.
I was wondering, where these names come from? And then I'm looking up here.
We are the children of one father, and the breast of one mother hath given us suck. Same blood, don't believe in luck, but remember the relation that binds us to unity and love. May the blessings of our fathers contribute to the support of us. Happy is the man who has sowed in his heart the seed of benevolence. January 8th, the prophet's anniversary. I love to see the Moorishness. Moors are the closest. Talk to Allah face to face like Moses, and He tells us heaven. Allah chose us. We prayed, He heard us. Sent us a prophet. Now look at us. Hope our children learn to be industrious.
The prophet said the Moors once fed the world, we gotta do it again, hey. The prophet said the Moors once fed the world, we gotta do it again, hey. The prophet said the Moors once fed the world, we gotta do it again.